Okay, well, welcome the big crowd at the Dunellen Library. My name's Ken Vercammen. We're going to talk about wills, powers of attorney. If you have any questions, you can raise your hand. A lot of times people will say, Kenny, why do I need to have a will? I'm married. Doesn't everything go to my spouse? He goes, well, yes and no. If it's a first marriage, yes, but that's not doing planning. That's like not changing the oil in your car and hoping that you can sell your car before the whole engine falls apart. If you don't have a will or it wasn't signed properly or done properly, it costs the family thousands of dollars more. Because the person who becomes the administrator has to take a thing called the surety bond. If there's no will or wasn't signed properly, all the potential beneficiaries will have to sign what's called a renunciation saying, hey, we agree upon this person being the administrator. Well, that's sometimes people say, oh, my kids would all agree. He goes, well, of course they're going to agree now when you're around. They're not going to say, oh, no, I'm going to fight them to the death. But the whole part of planning is, it's people coming to my office. Oh, dad wasn't planning on passing. He died, but he got remarried. He goes, well, because he didn't have a will, that means that his new wife that he was married to for 2 years gets more than 50% of everything. Let's see. And in one case that we're working on, we're trying to create new law. The wife, after 2 years, filed for divorce. But the divorce never went through because of COVID and she didn't pay her lawyer. Well, what happens now? Well, she goes, well, I'm entitled to under the law. So we're trying to see if we can find an appellate judge to do the right thing. But the law is the law. When there's no will, you kind of lose the ability to reduce taxes or expenses. If there's minor children, a total stranger in the courthouse determines who gets custody. So when people have minor children, I go, listen, there's no best person to raise your kid. Who don't you want? But more importantly, when people are, grieving and under stress, they shouldn't be stuck with one more thing. I go, if you want to make things terrible for family, the seminar really is, don't do anything, and it'll cost them thousands more in the long run and cause stress. It's not because I tell people because I make a whopping $400 or whatever it might be. It's because I've seen this. When someone has planning, it's very smooth because New Jersey really is the easiest state for probate if someone has a valid will. There's no inheritance tax if it's going to children or grandchildren. There's no estate tax except for the people in the back row that have like $12.5 million. But there's no estate tax for everyone else. So in the old day, and believe it or not, we've made things easier since COVID. Because the old days, it was telling people, okay, we need you to make an appointment, drive out, find a parking space, then you're going to fill out a form, and then when I first started, it was like me writing down on the old yellow legal paper. Well, what now? Since COVID, even before we started emailing the questionnaire, and that was better because people could kind of decide before they would come into the office what they would want. Because we've had people arguing in our reception area. No, I want this person as the second executor. No, that your brother's no good. So people, we simply email out a questionnaire. Some people say, I don't have email. He goes, do you have children that have email or grandchildren that want money? They will help you out. Now, some people don't have email. Their kids help. I need to talk to them, and they have to at least tell me over the phone kind of what they want before we start the document. So, lady calls up. My mom, wants to have a will. Okay, I got to ask you, almost the obvious questions. But can your mom read and write English? Yes. Spanish is her first language, but she can read and write English. Okay. Can she tell me how many kids are there? 2. Can she tell me over the phone she wants you as the executor and it gets divided equally? Because if someone can't tell me that right away, then I can't do it. I can't jeopardize my license. So logistically, someone fills out the the form, and the form's not that complicated. 10 years ago, it was 8 pages long. Now our short form is 1 page long. Who's executor 1? Who's executor 2? Who gets your stuff? And is there any specific bequests? Let's say, and nothing. Nothing. I don't need to know what someone has because there's no estate tax. I don't need. We don't need to do sophisticated planning as long as we're in New Jersey. There should only be an executor 1, executor 2, not joint executors. You're creating twice as much work. Person this week says, "Oh, we want to have both kids as the joint power of attorney." He goes, "Worst thing ever. I won't do it because the bank is not going to honor it, and then you're going to come back to me and says, why didn't you tell me not to do this?" If there's joint, the banks are going to make both people come in and do everything. The whole idea of doing these powers of attorney and wills and living wills is to make it easier for the family and not give them more stress. And also based upon conflicts of interest law, we have to make sure it's what that person wants. So, we get calls, "Oh, mom wants to do a new will." Okay, we can send you the form, but we need to talk to her. Well, she can't really express what she wants. Well, then we can't do it. That's another reason why you want to try to get your documents done now while everyone is good. And, there's an executor 1 and executor 2. Certain assets don't pass direct and don't pass under the will. So if a house is owned husband and wife, let's say automatically go, and the deed says that, then automatically goes to surviving spouse. No need to do a new deed. Other assets pass by title. Think of bank accounts payable upon death, joint, automatically goes. A will can't change that. Other assets pass by contract, IRA, 401k, anything that has a beneficiary. The will can't change that. So it's also important for people that they can say, okay, if they want someone to get specific things, they should have it. But I do recommend that people get a printout, an old-fashioned printout, that pieces of paper that say who's the beneficiaries. Because don't assume someone who contacted us because they said, "Dad filled out the forms to make me the beneficiary on, the IRA. We sent it in, and he passed, and they said they don't have it." Well, then you're not the benefit. But I saw him sign it. Do you have a copy? Do you have proof it was sent in? No, but he goes, I told the person, don't waste your money. I love making money, but you just be wasting your money because the judges are going to say, no, you got no proofs at all. So, get some printouts. There are other reasons why I tell people sometimes get printouts is because you got to make sure that those are who the beneficiaries are. I was married for 11 years, and I found that my father was still the beneficiary on some of my life insurance policies. I assumed they changed them. I know my dad would do the right thing. Let's see, just like everyone in this room is sure that their children or family will do the right thing until after you pass away. And if someone said, "Oh, okay, someone said, "Okay, yeah, you're the lawyer. Do I have to share this money do I have to share this with everyone else?" I go, "Well, legally, no. I mean, you should do the right thing." When I was in grammar school and the nuns kept on smacking us for doing whatever was wrong or we might have did good. But they also taught some sense into us saying, it's all about, doing the right thing. Okay, so your will sets forth who gets your stuff. Some people have specific bequests. Yes, ma'am.
So when you say do the right thing, right?
Yeah.
Let's say you have 5 kids, 4 kids, and you don't wish for them to all equally benefit.
Okay, so let me talk about it's your right to do what you want in your will. So last year, one of our clients said, came in and goes, "Do I have to leave everything to my children equally?" He goes, "No, it is your right to do with your money what you want. If you want to leave everything to the Yellow Dog Society, you can do that. Okay, what's your concern?" And the lady goes, well, one of my sons lives on the West Coast. I don't see much of him. I goes, well, I'll ask you a couple questions. Did he call you or send you a card on Mother's Day, your birthday, or Christmas? She goes, no. I goes, why would you leave this guy anything? He's a bum, and he's going to be the worst person. The day you pass, ain't going to be at the funeral, but he's going to be bothering the executor. Where's my money? I want my money. And whoever that person's married to is going to be the bigger loudmouth. When are we getting our money? So some people don't have children or close family. He goes, listen, think about who's been nice to you, or some of the charities or groups that you've that you enjoy, and make it better for them. Let's say because why should some third cousin that you might not have heard from in 20 years get your windfall? I mean, who in this room has worked almost their whole life so that strangers can get their money? Not too many people. I'd say. I mean, sometimes people ask me about I want to protect my assets in case I have to go into a nursing home. I said, not me. I want to go into the most expensive nursing home, because if I am that sick and ill that I can't get up and do my own stuff for those last weeks or months, whatever, I want the best care possible. Because also, why should I go into the dirty, smelly, Medicare nursing home and give away my money so my son, Dr. Brennan, can get a bigger boat? Let's say, yeah. So, but at least that's me. So it's your right to leave whoever you want. Yes, sir.
On that, let's say the one child that you don't give anything to.
Yeah.
Can they challenge it and that would hold up things? Or
well, if they have the money to hire a lawyer. Right. So for someone, when someone passes, you want to put a clause, just a simple line in the will saying, I leave nothing to this. You don't leave him $1. There's no reason. You don't leave him $1 because then you got to chase him down and get him to cash a check. Okay. So let me talk how easy probate is in New Jersey. Okay. Let's see. We fill out a one-page form. We email or fax it to the surrogate. We fax them a copy of the will, fax them a copy of the surrogate. I mean the death certificate. They email or fax us papers to sign. The person signs in our office, or they can sign at the surrogate, and the surrogate's reopened by appointment. And there's a fellow that's going to be signing papers in my office at 10:30 on Friday. At 11:30, he's going to be in the surrogate's office. So here's the original will, death certificate, check for $160. And they're going to say, okay, here's your papers. Good luck to you. So New Jersey. So then what happens next is the executor or their attorney sends out a notice of probate to everyone who's a beneficiary in the will and everyone that would have inherited if there was no will at all, including the person that you excluded. So they have 4 months in which to file a formal complaint and order to show cause in the Superior Court of New Jersey, saying, I challenge the will. We get a call once a week from someone that wants to challenge a will. So last week I called up the guy, and I forgot where I met him, because he gets our email newsletter, but I go, okay, you're excluding the will. The judge is going to ask you these couple questions. Let's see, when's the last time you saw your father in person? He goes, 3 years ago, we had a falling out. Judge is going to ask you, did you send him a card or a call on his birthday, Father's Day, or Christmas, or call him? No. Sir, don't waste your money. What's your grounds for challenging it? You weren't provided for, but the judge is going to say, well, you had a falling out. That's his right to do what he wanted. I mean, you're not going to find an attorney who's going to take it on a content. You might find a young lawyer starting out that wants practice. I mean, I've been in practice for 35 plus years. When I was a young lawyer, I took, junkie cases. But I don't take junkie cases now. Okay. Yes, ma'am.
If grandchildren were in the will,
yeah,
and a codicil was done, taking them out of the will, can they challenge them?
Again, to challenge a will requires filing a complaint order shall cause in the Superior Court. There is no fill-in-the-blank form that the courts have to challenge a will. And the reason was because they don't want more work from disgruntled people that shouldn't be getting whatever. And like, the whole grandkid thing, like, we often do wills saying, Mrs. D, if my son dies, everything's going to my other son and not to that son's kid because he hasn't visited me or said hi to me in 5 years. He's 30 years old, and I know my son didn't raise him wrong. So if he doesn't want anything to do with me, why should he get money? Okay, did that answer the question? Go ahead.
Yes, it did. For the codicil, I mean, I did go online and look. It's in New Jersey, a codicil that's notarized can be accepted.
Well, the problem with do-it-yourself stuff is like do-it-yourself electrical work or do-it-yourself plumbing. If it wasn't properly signed with 2 witnesses and a notary, then the surrogate's going to say this doesn't go on. Think of the surrogate as in a way a fancy name for the will clerk. I mean, there's so many other duties, but when everything's done right, the surrogate staff says, okay, here's your papers. But if it's not properly notarized with the 2 witnesses, then they just, okay, nope, can't go in. You got to spend, $3-4 grand, the executor admitting this to probate. So, it's in a way, all these like cheaper free online things have been a boon to attorneys doing probate stuff because people didn't do it right. And then they got to spend a lot of money going to court. Everyone got to be notified and it becomes a project. We also want to put in a clause that says like no one under 21 or 25 gets money because the legal age is 18. But how many 18, 19-year-olds would ever do smart things with money? I mean, if I got money when I was 19 years old, I would have bought a red fast car and went down to the seaside with all my friends. And he goes, okay, who's of legal drinking age that, is going to get us cases and kegs of beer. So you want to sometimes protect people. Sometimes we put clauses in that has what's called the testamentary trust for adults because they're either spendthrifts or have alcohol problems, drug problems, and knowing that they would just blow through the money within a year. But that's something you discuss with the attorney. Some people have specific bequests. That is where an amount of money goes to someone or a specific item. So sometimes someone says, "Okay, listen, I want my jewelry and what was my mom's jewelry to go to this this daughter or this granddaughter because lady goes, my son will take this to cash for gold, and what do you give me for this junk?" I'd say some of the men are sportsmen. It goes, okay, they have hunting rifles or stuff. It goes to someone in the family that has a firearms permit that might get to use it. I don't have a clue how much my valuable baseball cards are, but my son got all of the autographed Hall of Fame photos, and I gave it to him now since I moved out of the giant house. Because you know what am I holding on to this stuff for? That way at least I can say I gave you some of your inheritance earlier. I'd say with people with minor children, they have a guardian. Get your documents done. I'd say old man Carl kept on saying, "Oh, I want to read more up on this. I want to read more." Carl, you don't need to read anything. I went to law school. I go to seminars. I wrote a book on this. You don't need to read anything. When I had knee surgery, I didn't want to know about how they were doing it or read about it. Well, I want to read. He was an old school engineer. Okay, 2 years later, Carl's daughter calls. "Oh, my dad died. Do you have a copy of his will?" No. He kept on wanting to read up on stuff. So don't wait. Anyone who attends our programs, I tell people, listen, we typically charge a $200 consult fee, but if you contact us within 30 days, we don't charge that. My mother-in-law used to call me every other year and say, "I want to come in and get a trust done." And I would say, oh, I see you watching Susie Orman again. Yes, Susie Orman is so right if you live in New York, California, Florida, where probate is very, very complicated. But New Jersey, probate costs $160. So I ask people, why do you think you need to have a $5,000 trust if the will cover most of your stuff?
What is
Now,
trust?
a trust is where it's to avoid probate. So in Florida, for example, let's say instead, the property, if someone owned under a condo in Florida, instead they set up a trust, and the trust owns the property. That way, it doesn't have to go through Florida probate, which could cost $15,000 just on the probate. But in other states, there's trust salesmen. But New Jersey, you don't need to change who owns your assets into a trust because probate is easy. Some people, though, set up what's called an irrevocable trust. What an irrevocable trust is where you take what you own and put it into a trust that can never be modified, never be changed. You don't own your house anymore. You don't own your assets. And you're saying, in case I have to go into a nursing home, it's to protect my assets. But the look back period is 5 years, and not that many, very few people say, you know what, I don't really want to give up control of, ownership of all my assets. I want to thank the group in the